Today on Bench Briefs, we're looking at an important decision from the federal court that shines a light on how refugee claims should be assessed in Canada. The case is Abubakar versus Canada, Citizenship and Immigration, a 2026 ruling that reminds us of the need to interpret refugee law with purpose and fairness. So, what's this case all about? Abubakar is an individual who came to Canada seeking protection as a convention refugee. That means he asked the government to recognize that he faces serious risks if he returns to his home country, risks that fall under the protections of the 1951 Convention relating to the status of refugees. The government's citizenship and immigration authorities made a decision on his claim, but Abubakar wasn't satisfied. He argued that the administrative body didn't apply the law correctly, specifically that they failed to use a purposive approach in line with the Refugee Convention. He asked the federal court to review that decision. Here's the background in a bit more detail. When someone applies for refugee status, the authorities have to assess the claim carefully, considering the reasons why the person fears persecution. The Refugee Convention isn't just a dry list of rules. It's meant to protect people genuinely in danger. That means the decision makers need to interpret and apply it in a way that reflects its humanitarian purpose. Abubakar's claim was denied, and he felt the decision makers had taken too narrow a view, missing the broader protective spirit of the convention. He sought judicial review, which is a process where a court looks at whether the administrative decision was lawful, fair, and reasonable. The federal court had to consider two main issues. First, did the administrative decision properly apply the purposive approach required by the Refugee Convention? In other words, did they interpret the convention in a way that fulfills its protective intent? Second, was the decision lawful under administrative law principles? This includes understanding the right standard and scope of judicial review, specifically whether the court should intervene by certiorari, a type of review that can quash decisions if they're made in error or outside legal boundaries. The court's analysis focused heavily on how to balance respect for administrative decision makers' expertise with the need to ensure that refugee claims are treated fairly and in line with international obligations. The key takeaway was that decision makers must not apply the convention in a rigid or overly restrictive way. Instead, they should interpret it purposively, meaning they consider the convention's goals and humanitarian purpose when assessing a refugee claim. If an administrative decision fails to do this, it risks being unreasonable or unlawful, opening the door for judicial review. The court emphasized that the standard of review isn't about reweighing evidence, but about ensuring the decision fits within the legal framework and respects the convention's intent. Why does this case matter? For one, it clarifies how Canadian courts expect refugee claims to be handled. Refugee law is a critical part of Canada's commitment to human rights and international protection. This ruling reinforces that the law isn't just a checklist, but a living instrument designed to protect vulnerable people. It also reminds administrative bodies to approach their decisions with the right mindset, one that looks beyond technicalities and focuses on the real risks claimants face. For lawyers and claimants alike, Abubakar versus Canada is a useful precedent. It shows that courts will hold decision makers accountable if they fail to apply the law properly, especially in cases involving fundamental rights and protections. It also highlights the proper role of judicial review in immigration and refugee law, respecting the expertise of decision makers, but stepping in when necessary to uphold fairness and legality. In the bigger picture, this case is a reaffirmation of Canada's role as a safe haven for those fleeing persecution. It underscores the importance of interpreting international protections in a way that truly serves their purpose, not just ticking boxes. For anyone interested in refugee law, administrative law, or human rights, Abubakar offers a clear example of how the courts balance these complex issues. Thanks for listening to this episode of Bench Briefs. Be sure to join us next time for another dive into the cases shaping Canadian law.